Dear viewers, in the last session we discussed remedies for misstatement in prospectus and rules relating to issue of deposits by public companies. In this session, we are going to discuss the concept shareholder or member of a company. The objectives of the lesson are as follows: A. To explain the concept of shareholder and member. B. To explain who can become a member of a company. C. To explain how to become a member and cessation of membership. D. To explain the allied concepts like forfeiture of shares, lien, surrender, calls on shares. The member or shareholders of a company are the persons who collectively constitute the company as a corporate entity. The terms member or shareholder are used interchangeably. In the case of an unlimited company or a company limited by guarantee, a member may not be a shareholder, for such a company may not have a share capital. A registered shareholder is a member, but a registered member may not be a shareholder because the company is a company limited by guarantee. A legal representative of a member of a company may be a shareholder, but he is not a member of a company until his name is entered as a member of the company in the register of company. Companies Act 2013 abolished the concept of share warrant. According to section 2 subsection 55 of the Act, member in relation to a company means A. The subscriber to the memorandum of the company, who shall be deemed to have agreed to become member of the company and on its registration is to be entered as a member in the register of members. B. Every other person who agrees in writing to become a member of the company and whose name is entered in the register of members. C. Every person holding shares of the company and whose name is entered as a beneficial owner in the records of a depository. Holding equity shares through depository constitutes the holder a member. A person who holds shares in a demat form, his name does not appear in the company's register of members. D. Shares can be held jointly. The principles relating to rights and liabilities under joint promises would apply. Who can become a member? Any person who is competent to contract may become a member of a company. Now, let us examine whether the following persons can become members of the company. A. Minor. As a general rule, minors' contracts are voidable. So, a company may allot shares in favor of a minor and his name may remain on a company's register of members, but during his minority, he incurs no liability. In Palaniyappa Mudaliyar versus Official Liquidator, AER 1942, Madras 470, shares were allotted to a minor on an application signed on her behalf by her guardian. In the winding up of the company, neither the minor nor her guardian were held liable as contributors. Therefore, a transfer of fully paid shares in favor of a minor on the basis of transfer deed signed by his natural or legal guardian is perfectly valid unless the articles of the company expressly forbid registration of such transfer. He shall incur no liability whatsoever during his minority. B. Registered company. A registered company, being a legal person, may become the member of another company only if it is so authorized by its memorandum of association. C. Registered trade union. A trade union registered under the Trade Unions Act is a legal person and so it can be registered as a member and can hold shares in a company in its own name. D. Partnership firm. A partnership firm, not being a person, cannot buy shares in its own name. It may buy shares as part of the assets of the firm, though they will have to be held in the name of individual partners. E. Foreigner. A foreigner or non-resident Indian may take shares in an Indian company and become its members with the general or special permission of Reserve Bank of India. F. Receiver. A receiver appointed in respect of certain shares of a company cannot exercise any membership rights attached to the shares unless in a proceeding to which company is a party, an order is made therein. In Balakrishna Gupta vs. Swadeshi Polytechs Limited, 1985-58 Company Cases, page 563, Supreme Court held that the appointment of a receiver therefore cannot deprive the holder of the shares whose name is entered in the register of members of the company the right to vote at the company's meetings. Modes of acquiring membership. A person may acquire the membership of a company in any of the following ways. A. By subscribing to the Memorandum of Association. Deemed members. The subscribers to the Memorandum of Association of a company are deemed to have agreed to become its members. When the company is registered, their names are entered as members in the Register of Members. In Manager, Court of Subaspur Bilroy Estate vs. Equity Insurance Company Limited, AER 1944, Aud, page 197, it was held that his rights and liabilities as a member shall commence from the date of incorporation of the company, irrespective of the fact whether he has actually taken the qualification shares or not. A subscriber of the memorandum cannot rescind the contract for the purchase of shares even on the ground of fraud by the promoters. Thus, in Remetal Company 1902, 1 Chancery, page 707, held that a subscriber having signed the memorandum is bound to the extent of shares held by him. In this case, a subscriber agreed to take 350 shares. Thereafter, he wanted to rescind the contract on the ground that he was induced to sign the memorandum by misrepresentation on the part of the promoters. It was held that since he brought the company into existence by his own act, he cannot rescind the contract. A subscriber must take the shares directly from the company and not through transfer from other member. His liability shall continue right up to the time when company goes into liquidation. B. Qualification shares, section 266. This has been dropped by Companies Act 2013. C. By an application and allotment. Prospectus is an invitation to offer. An application for shares is an offer to take shares. Allotment of shares by the company is acceptance of that offer by the company, which creates a binding contract between the applicant and the company. D. Agreement to be in writing. An agreement to become a member has to be in writing. As such, person cannot be deemed to have become a member by means of acquiescence or estoppel simply because his name is entered in the register of members. E. By transfer of shares. A person may purchase shares in the open market. He becomes a member when the transfer of shares is effected and his name entered in the register of members. Shares in a company are movable property as provided in section 44 of the Companies Act 2013 and are therefore transferable in the manner as provided in the articles of the company and in accordance with the provisions of the section 56 of the Act. It must be stated that existence of the name in the register of members of the company is only prima facie evidence of the membership and not the conclusive evidence of it. F. By transmission. A deceased member continues to be a member of the company so long as his name appears in the register of members. His legal representative who acquires a legal right to shares is entitled to have his name entered in the register of members. The company also has the power to register any person as a shareholder to whom the right to any shares or debentures in the company has been transmitted by operation of law, and in such a case an instrument of transfer is not necessary. Section 56, subsection 2 of the Act lays down the formalities of transfer, specially provides that nothing in the section prejudices the power of the company to register as shareholder any person to whom the right to any securities has been transmitted by operation of law. G. Depository. The holder of shares through depository will acquire membership of the company. H. Section 72. Nomination of shares and debentures. This section provides the facility to shareholders, etc., to register the name of any person with the company in whom the shares will be vested on the death of the nominating shareholder. Debenture holders and deposit holders have also been given similar rights. Termination of membership. A person shall cease to be a member of a company when his name is removed from register of members for a valid reason. The name of a member may be removed from the register of members under any of the following situations. A. Transfer of shares. When a member transfers all his shares to another person and the transfer is registered in the company, his name shall be removed. According to section 285 of the Act, he shall, however, remain liable as contributory under B category if the winding up of the company commences within 1 year of his cessation as a member. B. Transmission of shares. When any member dies or becomes insane, his shares are transmitted to his legal representatives who become the members of the company after their names are entered in the register of members. If a member becomes insolvent, his shares are transferred to the official assignee. C. Expulsion. When a member is expelled from the membership in accordance with the provisions of the company's articles, member's name will be removed from the register of members. D. On winding up. Once the winding up proceedings are commenced, the members are called contributories. E. Voidable contract. When the member rescinds the contract of membership on the ground of fraud or misrepresentation in the prospectus, first he has to avoid the membership of the company. F. Forfeiture of shares. When his shares have been validly forfeited, surrendered or sold by the company to enforce its lien for unpaid calls, the membership of the member ceases. G. Redemption. When member shares are being redeemable preference shares have been validly redeemed by the company. Calls on shares. Every shareholder is under a statutory liability to pay the full amount of his shares as section 10 subsection 2 of declares that all money payable by any member to the company shall be a debt due from him to the company. But the liability to pay this debt arises only when a valid call has been made. However, according to section 50 of the Act, a company can accept voluntary payment of the uncalled amount if it is so authorized by its articles. An enforceable call shall have to conform to the provisions of the Act and the articles of association of the company. The following are some of the important requisites of a valid call. A. By resolution of the Board of Directors. In the first place, a call must be made under a resolution of the Board of Directors. B. Amount and time of payment. The resolution must state the amount of the call and the time at which it is to be paid. Otherwise, the call will be invalid. C. Bona fide in the interest of company. The capital of a company is a trust fund in the hands of the directors. The amount called up must be used scrupulously for the objects of the company, and the amount uncalled must be called only when it is necessary for the promotion of those objects. Hence, the power to make call is in the nature of a trust and is to be exercised in the interest of the company. In European Central Company Re. 1872, Law Reports 13, Equity, page 255, where the directors paid into the company's account the amount due on their shares and immediately thereafter withdraw it as their fees. It was held that the payment was not for the benefit of the company and they remain liable to pay. D. Uniform basis. Section 49 of the Act provides that calls shall be made on a uniform basis on all shares falling under the same class. Hence, a call cannot be made on some of the members only unless they constitute a separate class of shareholders. E. Shares may be paid for in cash or kind or in any other manner that has the effect of actual cash being received by the company. Forfeiture of shares. If a shareholder, having been called upon to pay any call on his shares, fails to pay the call, the company has two remedies against the shareholder. Namely, it may sue him for the amount due, it may forfeit his share. Forfeiture means depriving a person of his property as a penalty for some act or omission. The company may forfeit the share of a shareholder for non-payment of calls if the following conditions are satisfied. 2. In accordance with the articles. A forfeiture must be authorized by the articles of the company. Forfeiture is in the nature of penal proceedings. 3. Notice prior to forfeiture. Before shares can be forfeited, the company must serve a notice on defaulting shareholder requiring payment of the unpaid call together with any interest which has accrued. The company must give not less than 14 days time from the date of service of notice for the payment of the amount due and state that in the event of non-payment of the amount due within the period mentioned in the notice, the shares in respect of which the call was made will be liable to be forfeited. The notice of forfeiture must also specify the exact amount due from the shareholder. If the notice is defective in any respect, the forfeiture will be invalid. 4. Resolution of the board. If the defaulting shareholder does not pay the amount within the specified time as required by the notice, the directors must pass a resolution forfeiting the shares. If this resolution is not passed, the forfeiture is invalid. 5. Good faith. The power to forfeit shares must be exercised by the directors in good faith and for the benefit of the company. Effect of forfeiture. 1. Cessation of membership. A person whose shares have been forfeited ceases to be a member in respect of the forfeited shares. But notwithstanding the forfeiture, he remains liable to pay to the company all monies which at the time of forfeiture were payable by him to the company in respect of the shares in case the company goes into liquidation within 1 year from the date of forfeiture. 2. Reissue of forfeited shares. Forfeited shares become the property of the company. These may be reissued or otherwise disposed of on such terms and in such manner as the board thinks fit. Surrender of shares. When a shareholder of a company voluntarily gives up his shares in favor of the company, he is said to have surrendered them to the company. Where the articles give power to the directors to accept surrender of shares and it is accepted in case of partly paid shares to save the company from going through the formalities of forfeiture, the surrender is valid. Surrendered shares can be validly reissued in the same way as forfeited shares if the articles authorize their reissue. There is no reference in the Act to surrender of shares. Lien on shares. The right of lien is not inherent but must be clearly provided for in the articles. It is safer to adopt clauses 9 to 12 of Table A, which provide for this right. Lien is the right to retain some property for some debt, and in the case of a company, lien on a share ultimately means that the member would not be permitted to transfer his share unless he pays his debt to the company. Section 88. Register of members. Every company has to keep and maintain certain registers in such form and such manner as may be prescribed. Such registers are register of members, debenture holders or any other security holders. Where shares or debentures are held in the demat form, the register and index of beneficial owner maintained by a depository under Section 11 of Depositories Act 1996 is to be deemed as an index and register of members and that of debenture holders as the case may be. Section 89. Declaration of beneficial interest in shares. Sometimes shares of which A is the real owner may be registered in the name of B. A is the beneficial owner and B is the trustee. Then B is required to make a declaration within the prescribed time and manner to the company specifying the name and other particulars of the person who holds the beneficial interest in the shares. The failure on the part of registered owner and beneficial owner to file the declaration without reasonable cause entails the penalty extending up rupees 50,000 and if the default is continuing nature, rupees 1,000 for every day of default. If the company fails to file the return with the Registrar of Companies within the time specified in Section 403, subsection 1, the company and every defaulting officer become liable to fine of rupees 500 extending to rupees 1,000 for every day of default. Section 90. Investigation of beneficial ownership of shares. Where it appears to the central government that there are reasons to do so, it may appoint one or more competent persons to investigate and report as to beneficial ownership of any shares or class of shares. Section 92. Annual return. Every company has to prepare a return to be known as annual return in the prescribed form contained in section 92, and the return has to be signed by the director or the company secretary or the company secretary in practice. Every company has to file with the registrar a copy of annual return within 60 days from the date on which the annual general meeting is held. Section 92, subsection 5 and subsection 6, penalty provisions. Where a company fails to file its annual return either originally or with additional fees under section 403, the company is punishable with fine for an amount of not less than 50,000 rupees, but extending up to rupees 5 lakhs. Every defaulting officer is punishable with imprisonment for a term which may extend to 6 months or with fine of not less than 50,000, but extending up to 5 lakh rupees or both. Section 57, penalty for personation as a member. Where a person knowingly and deceitfully personates a member, he shall be liable to punishment under section 57, subsection 6 of the Companies Act 2013. As per section 416 of the Indian Penal Code, personation is a kind of cheating and the offence is committed whether the individual personated is a real or imaginary person. It is an offence punishable with imprisonment, which may extend to 3 years or with fine or with both. In this lesson, we discuss the concept of member and who can become a member of the company and how to become a member and termination of membership. In addition to this, we also discussed rules relating to calls and forfeiture of shares. I hope you enjoyed this session and we will meet in the next session. Thank you one and all.